Paul Foster-Bill.
Mr Speaker, thank you, sir. Sir, contrary to some of the things said by the previous speaker, we on this side of the House are not patting ourselves on the back prematurely over this bill, the Weathertight Home Resolution Services Amendment Bill. It is an important piece of legislation, and as my colleague, the honourable member from the Coromandel, Scott Simpson, said, it is timely, it is pragmatic, and it is something that is required to address the concerns that affect so many New Zealanders who have had leaky homes. But it is not something that we take particular pleasure in having to do to fix up a mess that has been present in this industry over a number of years and across the tenures of 3 governments now. We welcome the Labour Party's support of this piece of legislation, and I actually agree with the honourable member Clayton Cosgrove. It isn't as simple as writing a cheque, and we shouldn't let that tiny minority of builders who were dodgy, and the housing designers, the architects, the engineers and the certifiers who also played a part in leading to a situation where a number of New Zealand houses were not built to a standard which could be reasonably expected with regard to weather tightness. We shouldn't let them entirely off the hook. But this is important to a subset of the owners of leaky homes who have been affected, so I think it is timely that it's introduced into the House now. Sir, if I can go back to the PricewaterhouseCoopers report that Mr CO referred to in his speech, the estimate was between 22,000 and 89,000 homes that were affected by weather tightness issues. But the consensus among the experts who looked at this, including people from the Weather Tightness Home Resolution Authority, or the tribunal which assesses these cases, but also brands, the Building Research Association of New Zealand and other industry players, was that the likely figure was around 42,000 dwellings in New Zealand, which means 80,000 Kiwis were affected by weather tightness issues. And the reason I bring this up, sir, is to give members a sense of the scale of the issue that we found when we came into government in 2009, because what had happened prior to that, yes, a tribunal had been introduced and people who had leaky homes were able to take their claims to that tribunal to be heard, but many thousands of New Zealanders were still left in a terrible position, because the circumstance we found when we came into office was that in terms of the costs being met for a leaky home, 69% of those costs were accruing to the owner of the home, who in a few cases may have been involved in the building of their own home, as New Zealanders are an entrepreneurial and the number 8 wire mentality does still exist in this country. But 69% of the costs accruing to owners was not reflective of the fair attribution of liability or blame for the problem, in my view. 25% of the cost was being met by councils, which perhaps is a fair attribution of cost to councils given their role over many years in failing to issues that were present in buildings that they were consenting and authorising to be built. Only 4% of the costs in 2009 were actually being met by the third parties, the builders, the designers, the engineers, who one could argue played a larger part in the creation of this issue, and 2% of the costs were being met by government. That was the administration of that tribunal. So owners carried the largest share of the costs, and that was a situation which we didn't feel was fair to those who'd been affected, often through no fault of their own, by this insidious issue, and it's an issue which often takes many years for homeowners to even recognise they suffer from. So in 2011, the government announced the Leaky Homes Financial Assistance Package, and this was to give a greater government share, and neither we nor the previous government accept legal liability for this situation, but we did feel it was a fair solution to offer a 25% contribution to those cases which had been through the proper hearings procedure and had been recognised as being a duly affected homeowner who had been impacted by a weather tightness issue, a 25% contribution from the government, and then access to a loan should it be required with a government backing for that loan, so that homeowners could borrow the money that they might need to bring their home up to a reasonable standard so that it that could either go up for sale or remain habitable by the homeowner. Now, the fiscal implications of this issue are significant. As I've said, 80,000 individuals, 40,000 homes, and an estimate in 2008 dollars of $11.2 billion cost to the New Zealand economy. It was in the scale almost of a natural disaster and comparable to some of the costs that we've seen over the destruction of homes in Christchurch, for instance, after the earthquake. So that, sir, is to give the context for why we think it is an important piece of legislation that we're introducing now to remedy three particular technical aspects of the current system which have in recent litigation proven to be difficult or have led to various different interpretations and a difficulty in establishing clear precedent. The first of these is around the where in legislation this sits. And so the courts have taken some issue with the fact that by notifying in Gazette we are providing the criteria for claimants. We will move from the Gazette notification to actually codifying in the Act itself validity criteria to remove that doubt. It's not an issue which has actually impacted on individuals yet, but it was something that was identified by the courts. They've sought the guidance of this House to remedy that lack of clarity, and this bill does provide clarity in that particular instance. As my colleague Scott Simpson's referred to, another major issue has been around establishing the definition of when a building is built. Now, we know throughout the country there's currently with regards to the Resource Management Act, a lot of lack of clarity around measuring the height of a building. That was one example that's reached recent media attention, where we have 50 different definitions of how to measure the height of a building. Well, we have two different definitions that courts have referred to in terms of determining the built date for a building. And the reason the built date is very important is that is the date at which the clock starts ticking for those who may have suffered a weather tightness issue, given that there is a 10-year expiry period for the detection and the lodgement of a claim with the tribunal. So we've had a disparity between the High Court and the Court of Appeal, which have in recent cases determined the built date of the building to relate to the date that a final building inspection is conducted by the Council. Whereas the Supreme Court in the Osborne and Auckland City Council judgment, which was reached in June 2014, determined that the built date of the building, the date from which the building is considered to have been built, wasn't when the inspection happened, but it was when the code compliance certificate was issued. And there can be a considerable period of time elapsed in between those two events, between the council inspection and the issue of a certificate. So this does affect a number of claimants that are currently before the tribunal, and it behoves this Parliament to ensure that that is clarified, that we have a clear direction as to when a building is deemed to have been built, particularly so that we don't get disparities between individual cases, because it would be, I think in my view, very unfair to have a situation where a home was built on the same day in two different local authority areas, and because of these two different judgments they're treated differently in terms of eligibility to access the compensation that's provided by the Weather Tightness Appeals Tribunal. What this also does is ensure that that it does have retrospective effect, so those who would have been eligible had this provision been in place when they were previously perhaps denied access to a claim will have that opportunity to take their case up. The final technical element comes to cases which are currently before the tribunal. So it's once a case has had the notice to proceed issued, then they will be able to access the package even if it falls outside that 10-year limit, because as we know, the 23rd of July 2016 is the cut-off date, and there may be some homes where the owners are currently before the tribunal and can reasonably expect their case to be heard, because through no fault of their own there have been delays, particularly in the complex multi-home apartment buildings of the sort we have here in Wellington Central. In those cases with those complexities, those cases can take a long time. So, sir, this is an important piece of legislation. The government is certainly not patting itself on the back, but it's something we have a responsibility as a sensible government to progress, and I welcome cooperation with the opposition and commend this bill to the House.